Welcome, everyone. We'll start momentarily. Hello, everyone, and welcome. Thank you for joining us today. My name is Leslie Levy-August, Chief Marketing Officer at KYG Trade, and on behalf of the team, I'd like to welcome you to today's webinar, Trust But Verify, Guardrails for AI and Trade Compliance, and featuring an analysis of CBP Ruling 350722. As the rulings come out in IEPA, we thought we would dedicate a few moments to that topic as well. We didn't advertise it, but things are changing so fast, it makes sense to address it a little bit today anyway. We're excited that you're happy that you're with us and appreciate you taking your time out of your day to join the conversation. Before we get started, just a few housekeeping items so you do know how to participate. First, the chat is open throughout the session. Feel free to introduce yourself, share where you're joining from, or add comments as the discussion progresses. And our team will be monitoring the chat during the webinar. Second, we will be using the Q&A feature for questions. If a question comes to mind, please drop it in the Q&A panel instead of the chat. We'll address as many questions as we can throughout and at the end of the presentation. And if we don't get to your question live, we'll follow up afterward. Third, you'll see a few poll questions pop up during the webinar. They are quick and anonymous, and they'll help tailor the discussion to the audience. We encourage you to participate when they appear. Finally, today's session is being recorded, and a recording will be shared with registrants after the webinar. Before we dive in, let me briefly introduce today's speakers. First, Todd Smith. Todd is CEO and founder of KYG Trade and has spent many years working at the intersection of global trade compliance, technology, and enterprise risk management. He was formerly at KPMG and EY as a partner in their trade and customs practices. Todd co-founded KYG Trade 4 years ago to bring cutting-edge automation to global trade compliance. He's going to help frame today's discussion from a practical and a strategic perspective. Next, Anand Raghavendran is KYG Trade's Chief Technology and Product Officer with deep experience designing and implementing trade compliance-focused technology systems. Formerly of ClearNow.ai as Chief Product Officer and CEO of GT Connect, a global trade management system. Anand will walk through the operational and technical considerations, including how these concepts show up in real-world workflows. And lastly, we're pleased to be joined by Richard Wortman, a partner at Grunfeld, Desiderio, Lebowitz, Silverman, and Kleestad, and our special guest. Richard brings an external regulatory and practitioner perspective with extensive experience advising importers and customs brokers on trade compliance and enforcement issues. He'll share insights grounded in current regulatory and legal thinking and real-world application. We'll hear from each of them throughout the session, and we'll have Q&A during the session as well at the end. With that, Todd, I'm going to hand it over to you.
Okay, thank you very much for the intro, Leslie. Can everybody hear me okay?
Sounds good.
All right, so I showed this a moment ago, but we are going to be covering the latest ruling on customs business licensed companies that are providing services and AI classification, which is obviously near and dear to our heart at KYG Trade. We're also going to squeeze in some discussion on the IEPPA refund process and CAPE. And then based on the level of engagement and questions, we'll get into more of the meat of the presentation and the webinar and talk about practical guardrails around AI in trade compliance. And then we also have put together a really handy enterprise AI adoption checklist, which we'll go through just very briefly, depending on the amount of time that we have. I do see a poll question that popped up, Leslie, and I'm going to try to get rid of that from my screen. Did it show up? I'm just curious for
Yeah,
everybody to see.
yeah. It should, everybody should
I
be,
mean,
and they're
on my
completing
screen,
it.
I wasn't sure if it showed up.
Yeah.
But okay, so we're going to start off with our very esteemed guest speaker, Richard Wortman. Always enjoy working with you, Richard, and this ruling is timely. And why don't you, if you will, kind of lead us through your presentation here?
Well, Todd, thank you very much. And thank you to the KYG organization. Um, so, uh, the whole topic was called AI Guardrails.
Hmm.
And this was the first ruling that actually
Yeah,
addressed this very topic. So we thought it timely. So I think it's really important to discuss the underlying facts in this, and then we can talk to how it might impact how you work with your service providers. So here, in the key facts of ruling 350722, I should say this was published January 16th, but it was not made public until mid-March, because there's a 60-day window
right,
prior to the release. So here, in this case, what happened was we had an online platform. Online platforms are nothing new. But here, let's start with some key facts. Number one, it was a non-US entity. It was an unlicensed, that is, unlicensed to customs, foreign entity who were providing certain services. Those services include connecting an importer with a broker. It would provide a power of attorney to a third-party broker, so they would make the connection. What it doesn't say is if that power of attorney, by the way, is directly with the broker. That is, does the broker send it outside of the system, and does it doesn't say whether it's direct to the broker or derivative, that is through the platform. That becomes important because in 2022, the brokerage rules were made much firmer, requiring direct powers of attorney between a broker and an importer. So this platform had some other services. It also allowed an AI tool for classification. You don't have to use the brokerage services of this platform to use that. They have the platform set up an OCR tool so that it can pull the relevant data from entries, invoices, and other shipping documents like bills of lading to populate or create all the information needed to create a customs entry. And finally, although not part of the platform, apparently the platform operators were filing Customs Form 5106 with Customs. Now, Customs Form 5106 is a document which identifies an importer and attaches them to their EIN number, or if they're a non-resident importer, helps apply for a non-resident importer of record number. So what did the ruling hold? So clearly, it had no direct issue with online platforms. They are here to stay. And they're okay as long as those platforms are used for the transmission of information. However, Customs is very clear that you can't use the platform to actively prepare or file customs documents. Now, I would say that this platform, and it doesn't describe the facts, are different than those provided by those that are set up with Customs to file broker entries. That's a different animal. But the facts were actually did not talk to that. We know that the power of what the ruling found important was that, number one, the power of attorney must be direct between the broker and the importer. If I were advising these people, I certainly would, once the connection is made, I would have that personally I would advise that the importer should provide that power of attorney outside this platform and do it directly. So there could be no question. Customs was also very concerned that the chat function may violate confidentiality. Now, remember, a broker has duty of confidentiality to their customer. And Customs is concerned that the direct, even though it's direct communication between the broker and the broker and the importer, this chat function may violate that confidentiality. So I'm going to skip to a recommendation here and make a comment because I think it's important to this. Any broker who is going to use information and share information through any type of outside service provider should have a waiver of confidentiality in their power of attorney, or it could be a separate form, but there must be a waiver of that confidentiality. And there's some specific language to use, and certainly if that's important to anyone on this chat, they can reach out to me afterwards. So we move on to the question of AI classification, because that's really germane to kind of the discussion we're having today. And that is, Customs was very adamant that if you use an AI provider and they give you 6 digits of the HTS number. Now remember, six digits is what our international agreements with other countries are. 8 and 10 digits are US pieces to that puzzle. But Customs has held that they're going to presume that if it's kicking out a 10-digit number, the AI system that is, it would be doing Customs business. And therefore, that service provider would need to have a Customs broker's license. I think that Customs went a little overboard here. I think that while they addressed a case that had bad facts, or what I would consider bad facts, I think that it didn't look to all of the other opportunities that are out there that may or may not require a Customs broker's license. Finally, it did note, a little backhandedly, but it did note that advisors such as accountants and lawyers and other professionals could instruct on these things, but it wasn't very clear about what happens and didn't talk to 6 digits or 10 digits. Bottom line is, we've got certain recommendations that are really important. The most important is that if you're going to use a service provider, they need to be based in the US and the data needs to be based in the US. Number 2, I think this is very new and none of these companies are licensed brokers yet for the most part, but at least one corporate officer at the moment should be a licensed broker, and the licensed broker should be overseeing this process. And finally, I'm going to go back. I said this. I'm sorry.
Excuse me. I coughed.
Okay. And so finally, for those who are using brokers, they should freely grant the waiver of confidentiality for the service providers, whether it's the AI provider or frankly, it's for any outside service that the broker could be doing. So I think that this covers sort of the outline of a very long ruling. This was 12 pages.
Yeah.
This is a very short summary, but I think it covers the key points.
Yeah, thank you.
And with
Richard.
that, Todd?
Yeah, that was a great overview. As the founder and CEO of an AI company that's doing trade compliance type services, I just want everybody to know that we're based in the U.S. We're a U.S. Delaware C corporation. I am a licensed customs broker. Anand, who's on with us here, is a licensed customs broker. He's our chief product and technology officer. Our chief AI officer is a trade attorney who also held a license, and so we're feeling really good about our position. Another just very important distinguishing factor that I want to point out is that our platform is not currently designed, and we don't actually file entries. We don't have a direct connect, and we're not preparing entry documents, and we're not filing entries. So I feel like our customers and people that we serve should feel comfortable with our standing, and maybe we should open it up for questions now. I don't know, Leslie or Anand.
I will jump in, Todd. Actually,
Yeah,
there's
go ahead.
two questions related to this one. The first one, Richard, to you. Can we use Docusign for the importer to sign a POA?
Absolutely.
Okay.
Well, actually, let me give you a qualified answer. You can use it in almost every state as long as the state recognizes powers of attorney that are electronic. And believe it or not, there are two states that don't.
I was just going to ask.
New York, which has been put a big kibosh on this. And that's really based on the real estate industry, not on anything else. And I don't remember the other. I want to say it's Kentucky, but it may not be. The second one I'm not sure about. I have to be honest. But there are two states that do not permit the DocuSign of such documents. However, in this world, signing a document and sending it electronically back shouldn't be a big burden.
Shouldn't be. It definitely should not be. What else you got there, Anand?
The next question is, when we talk about, hey, at least one corporate officer who is a licensed customs broker, the question is, does the classification provider need to be the brokerage with the POA, or can it be an individual that's licensed and doesn't have a POA?
I think we're in virgin territory here. And so I think that prudence might dictate while this is walking through that the company, when they do their engagement with their customer, identify at least one of the licensed brokers as part of the team that's going to assist them. I think that what we're going to see over time is that some key providers are going to become licensed brokers to avoid this issue. Now, I think this is going to become very interesting because what about those people who use less formal arrangements? That they use the ChatGPT or Gemini or these things that are also kicking out 10-digit numbers. Is Customs going to make a broker penalty case against Outlook and Microsoft? I would hope not. But they are at least today violating this ruling.
And Richard, this is more my curiosity asking this question, not from the attendees. Traditionally, importers did not even have the need to have a licensed customs broker on their staff, and they were eligible to use any tools. Is this now changing that landscape and making an importer also to have a licensed customs broker on their staff? Any thoughts there?
There is no requirement that an importer have a licensed broker on their staff. Importers should use reasonable care. For certain importers, having a licensed broker may be the tool. Many importers use outside services. If you asked me this question 2 weeks ago, I would have said to you that that whoever owns the data is the person who should be asking that question. So if the data is owned by the importer should be able to do whatever they want with their data, including provide it to any service provider they want. This ruling seems to indicate that that's not really true if the service provider is crossing some line. I think that over time, what we will see is Customs may pull back from this ruling a little bit, or rather than pull back, clarify where those lines are. But certainly you don't need to have a licensed broker on staff. Over the course of years, certain times, I would say maybe it's not a good idea, because then is your reasonable care going to be higher than anybody else's?
Anand, are you also seeing the questions in the webinar chat?
I'm looking at the questions on the webinar
Yeah.
chat as well. Leslie, unfortunately, I think as panelists, we are not able to respond back to everyone. So any questions on chat, you may have to help answering them because Todd, I, or Richard can only respond to
Well,
host.
okay, so I can just, yeah. So
You can do for everyone?
there's a question who came through that I'll ask Richard in case you haven't seen it. And it appears to be coming from a broker who has obviously, brokerage software. And the example or scenario is, can they use AI through an LLM to extract their client information that needs to go into the broker's software, and then hit the button and submit the entry. That's an interesting one.
Well, it's an interesting one, but I think it's very factually specific. I think you have to look at what's the broker doing. Does the broker own the AI data, or are they using a third party? If they're using a third party, is that third party license, or are they relying on the broker's own license? I think there's a lot of questions here. I think there's more questions than answers at this moment.
Yeah.
But what I would say is that, I think that the classification program has to be more than just AI. There still has to be human intervention. Somebody's got to be reviewing what's happening. Now, obviously, if you have an importer who has a lot of repeat business, the matrix could be created to repeat that information. But if you're looking at different things, let's say you're working with an online mail order, we use the old-fashioned word mail order platform, who has thousands of items coming every day. There needs to be some supervision over the AI. The AI alone is, I don't know that that's a reasonable care. I think it's a good start, but I think that somebody has to check but verify.
Yeah, I think also there's a second part to the question, which is, should I get a disclaimer with my client to let them know that I am using AI? And from my perspective, what I can say there is probably most definitely yes. Like when we are talking to importers about using our software, and we're in a lot of very large enterprises, Fortune 50, global enterprises, and every single discussion that we're having does involve a review by that company's IT organization, security organization, and now what we're seeing are these AI review boards that corporations are forming, where they're really reviewing all aspects of our AI, how it's being used, guardrails, and that's the topic of one of the sections of our webinar today, guardrails around the AI, and what's happening to your customers' data when you're feeding it into the AI to pull information out. There could be settings within whatever LLM that you're using that either allow or prevent whatever it is you're feeding into the model to be ingested for public consumption and training purposes. So your client's data could make its way into the public domain just by doing that. And so I definitely think that it would be prudent to explain to your customer that you are using, an AI tool, and maybe get something acknowledged in writing, to that effect.
So Richard, I'm going to combine two questions into one. First,
Okay.
if the OCR is pulling data from documents to feed the ABI software, are they violating this ruling? Question number one. The second half of that question is, even if that happens, as a user, I'm reviewing the data and I'm hitting the transmit button before that entry goes to CBP. Is that acceptable?
Well, the ruling is silent. So let's start with that. Again, I still believe even though this ruling pushes away from it, that who owns the data is very important. And, if a broker is using a tool that, and they are checking, that's clear. That's reasonable. If they're not checking, that raises a whole different set of issues on the broker side. As to the importer, I don't think there's anything wrong with a broker using an OCR to cull their data. The question really is, or it was 2 weeks ago, if I importer cull all my data and then hand it off to the broker, I don't think there's a problem. There shouldn't be a problem. I think here what Customs is trying to say is, if you give your data to someone else in the OCR process, and they're processing that data, and that data is going to be used to make it a customs entry, then the party who's doing that work and feeding the data should have a customs broker's license. So I'm not sure if I'm answering the questions because it was a multi-part.
So I think the key there is, if there is a human oversight, even if it is like just a control on clicking a button, does that suffice? And if that human happens to be a licensed customs broker, part of an organization that's already a national permit holder, will that take care of it, even though there was an AI involved in extracting the data? Is kind of how I read that question.
And I'm going to kick that question down the road about 2 years, because I don't think that we're prepared to answer that. What I can say is that when the broker regulations were updated in 2022, not necessarily about AI specifically, but Customs was very clear. They weren't going to tell us what reasonable care by a broker was. And so each organization has to evaluate what works for them. I would say the mere pushing of a button is probably not going to be enough. There's got to be some qualitative review.
Yeah.
There's got to have to be some quantitative review, but there needs to be qualitative review. Now, does that mean every single classification that passes by? I probably not. But is there a number that makes sense based on the organization's workflow? I think that there needs to be some qualitative review beyond the magic of pushing the button to file.
So before we move on, Todd, last two questions. I feel ashamed. I should know the answer. I think I know the answer, but I'm still going to ask you: is sending a 5106 or transmitting a 5106 on behalf of an importer considered customs business?
Well, based on this ruling, it is.
Yeah.
Now, the interesting part is that there are other people who file 5106s. Couriers file them, generally in their capacity as a courier, because packages come into people who have never done business with customs before. Customs surety bond companies file. May have licensed brokers on the staff. They're not necessarily licensed brokers. Now, they work with customs regularly, but they're still not a broker. So I think that there's some, again, ambiguity that needs to be fleshed out here. But reading this ruling, just on the four corners of it, it says that a 5106 is doing customs business.
Awesome. Thank you. Two more questions, and I think the questions keep coming in, and there's a lot of interest.
It's fine. Yeah, these are all good. Let's keep it going.
So if an importer uses an OCR tool abroad, okay, not in the US, abroad, it's a related company. Let's assume they use an OCR tool abroad. They extract the data. They directly feed that data to the broker, which then feeds into the brokerage software for entry purposes. Is the broker in violation at that point?
And that's what the ruling covered, essentially.
Well, the ruling covered it, but the real question is, I still think the question with respect to this particular question is, whose OCR whose data was it at the moment? I mean,
And I think you pointed out, Richard, did the broker have a POA or an agreement with their client that they were sharing it with the offshore entity
well,
or the
so
third party
let's be
entity?
clear. So let's be clear. We know there's certain things you can't do. You can't OCR and have that data offshore. That is if you're a licensed broker. Customs has no right to tell an importer that they can't do it. Number one, they may own the OCR facility offshore. If it's their OCR facility, that's not an issue. The question becomes, I still believe, whose data is it? If it's the importer's data, they use an OCR tool of their choosing and they provide it to the broker. The question really becomes, what should the broker be doing with that data? Is it just merely transmitting it, or should they be doing some sort of qualitative review? And I think that is going to be on a circumstance by circumstance basis.
And this, in practicality, right? This kind of a world existed even before AI came into existence, right? Because there were EDI feeds that the importer would provide to the broker, and the brokers would consume the EDI feed on an entry and transmit to CBP. For me, I look at it only from that perspective. If it is importer provided data, doesn't matter what the source of how the data came into existence, why should it be different? That's a question to you, Richard. Maybe just from a extrapolation thought process.
I honestly, I don't think it should be different. But customs has. Let me say this ruling is based on some bad facts. It wasn't presented neatly, and it created some rulings. It created some results that are uncomfortable to all of us. What we will see, I think, over the next couple of years is that we will begin to see, we have to begin to see what importers are allowed to do. We don't see that in these rulings. They're like, okay, customs is just under these facts, this is bad, you can't do it. Unfortunately, they didn't talk about those other things in the universe that you could do. And so I think that over time, we're going to see some evolution. I don't think that this ruling is the end. I think this is just the beginning, especially in the AI world.
Yeah. So, Anand, if I may, so there's just one more question, and then we're gonna move on to the next topic, which is IEPA and CAPE. And so this question is: does the ruling apply in a scenario where an importer's trade department, who or which consists of licensed brokers, uses a third-party AI to get a quote idea of what the HTS may be, but then does its own review that HTS to confirm? And what I would say to that, again, if you're the importer and you're using a third-party AI tool, you yourself are not doing anything wrong. And as long as you review it and obviously have a human in the loop confirm it, then I think because you're licensed customs brokers in your department, you could say you're demonstrating and exercising reasonable care. The issue would be the company that's giving you the result. If all they do, this third-party company that you're using their AI tool for, if all they do is AI classification and they're in the US or actually maybe not even in the US, then that company should not be considered conducting licensed business. But if that company also files entries and does other things for the preparation of an entry, then that entity is conducting customs business, and it becomes a problem for that company, not necessarily you, the importer. Richard, would you want to comment on that?
I think you covered it, Todd.
Okay, all right. Okay, so moving on, we're all operating in uncharted territories, with rulings and trade remedy duties coming out and changing with every True Social tweet, call it what you like. As this slide shows, since April 2nd, Liberation Day, you can see that the number of Chapter 99 penalty codes, exemption codes, and even this notion of unstacking these codes has just really increased from nothing. I mean, the world before 2025 and Liberation Day to today, as you can see here, is markedly different. And what we're also seeing is that whereas lots of other government agencies got doged, gutted, whatever word you want to use, CBP and DHS has actually gotten more resources, and as you can also see, they are collecting more revenue. These are some unbelievable increases in the net revenue recorded. As you can see in fiscal year 2024, it was 660 million with an M. And then in fiscal year 2025, it jumped to 34.4 billion with a B. I mean, these are just staggering numbers. And that 1.18 billion is just for the first quarter, I believe, of fiscal year 2026 for customs. So, just a dramatic shift in the landscape that we as trade professionals are operating in. And now, we have the Supreme Court decision and this ability for just a few importers. Oh no, it's 330,000 importers, have the ability to claw back, some of those revenues that were collected. And, again, 166 billion in refunds across more than 53 million entries. And, the CBP is saying, guys, give me a minute. I need to figure out, how I'm going to administer, make sure that these refund claims are legit, and actually start processing refunds. And so they've come up with this consolidated administration and processing of entries CAPE system. There's been this, 5 steps to the refund process that maybe some of you have seen here. To me, and just looking at, what the requirements are here, it doesn't seem overly complex. Like most importers are able to get their ACE entry summary report. They're able in an Excel sheet to do some filtering, maybe a pivot table, come up with the entries where there was an IEPPA duty paid, and prepare a schedule and submit it to somebody somehow. It sounds like it's going to be this CAPE system. We don't know, how it's going to actually be uploaded, as it's saying here. But there's also been, quite a bit of talk online around concerns and risk associated with going after and asking for these refunds. Like we're hearing, other providers say that if you're going to ask for the refund, then you're opening yourself up to risk and a possible audit, which may be. I mean, anytime you go to customs and ask them for something, you could be opening up a can of worms. So, Richard, what are your thoughts on this?
Well, let's step back for a moment here. Let's talk about what has happened to date. So, February 20th, the Supreme Court held that that these tariffs were improperly being collected by the administration. What the Supreme Court didn't talk to, not surprisingly, was what the remedy is. Having said that, it's worked its way down the courts. The Court of Appeals sent it back to the United States Court of International Trade, the trial court, and said, post haste, take care of this, essentially. The Court of International Trade has been focusing using one case that was not the case that went to the Supreme Court, called Atmos filtration. And there have been a series of hearings and rulings. And essentially, these hearings went to, there's all these different fact patterns. How are we going to get the money back? Shockingly, Customs actually did come back with a plan. They call it this CAPE plan. This CAPE plan initially was supposed to be constructed within 45 days, but it was also supposed to only cover unliquidated entries that were in the ordinary process of liquidating, which means those that liquidated very quickly, for example, informal entries, as well as things where the time clock has expired at the back end, might not be refunded. Having the lawyers for the majority of the cases went before the court and said, look, this is a problem. Customs didn't come back with a satisfactory answer. And 2 weeks ago in Atmos Filtration, Judge Eaton said, well, you could file protests because that's still a legitimate way to get money back. And so finally, this week, another group of lawyers went before Judge Eaton, and Judge Eaton issued a follow-up ruling. And let me
That was
just
this
read
week?
that was actually let me see, it was filed on 3/27.
Guys, just talk about like real time. This is we're repeating this webinar because we had so much interest in it. We did the webinar last week. This is new since the last webinar.
Right. So in this ruling, it says, ordered that with respect to any and all unliquidated entries that were entered subject to IEPA duties, U.S. Customs and Border Protection is hereby directed to liquidate those entries without regard to the IEPA duties. That means basically give the IEPA duties back. Continues, any liquidated entries for which liquidation is not final shall be reliquidated without regard to those duties. Any liquidated entries for which liquidation is final shall be reliquidated without regard to the IEPA duties. For avoidance of doubt, nothing in this order addresses issues concerning duty-free de minimis treatment under Section 321. So this ruling,
reliquidate without the need for a protest?
In other words, if you believe this, if you believe the court's order and what Customs has set up, that everything is going to happen. If Todd, you believe in unicorns, so we,
in the financial speak, yes.
So if you look to this ruling, one could reasonably conclude that you don't have to do anything until this process is finished, and it doesn't matter if your things have liquidated or not liquidated. Of course, that raises the question, what about those people that don't have the wherewithal to file these claims or haven't filed these claims? I think the fact you're setting up
or what if they change?
Process,
what if somebody changes that whole after the fact and you never filed a protest?
Right.
Yeah.
We also don't know. I mean, the White House has still yet to follow up. There's still time to do anything. We're in limbo here. Yeah. From my point of view, the advice we have been giving clients all along was, number one, you need to be in court. That's number one. We go into court because then you have a remedy if things go bad later on. Number two, if you can file protests to cover yourself. The worst that happens, and this process goes into place, you withdraw the protests and you file in this system. But I think that
you don't want to be that guy that didn't do that.
Exactly. So yeah. I think prudence dictates that you still, CAPE program or not, I think that you need to cover yourself. And in order to cover yourself, while everything is just paused and nothing is happening other than in these one cases, that you should be in court. Your customs counsel, whomever you use, can get you into court.
And Richard, when you say when I hear a lawyer say you want to be in court, I'm thinking, well, yeah, the lawyer's going to make a lot of money. But in this case, this doesn't require a heavy lift, for an importer to file a CIT.
No, so you need to file a summons and complaint in court. There's no such thing as there's no such process where everybody can jump in together. This is each importer stands on their own, so they have to file their own case. A complaint is detailed and it's long, but the law firms that are doing this are now quite experienced at doing this. I mean, my firm has filed, I don't know, 7, 8, 900 of these cases already. And that's piece one. I don't want to speak for others. We're charging a flat fee to do it because the important thing is to get into court.
Mm-hmm.
Number two, I'm still not convinced that the matter of liquidation is settled. The court is still, I still believe that Customs is feeding the court what it wants to hear, not necessarily all the best information. And we don't know what's going to happen. So my recommendation conservatively is to file the protests. I will tell you, I have been as a lawyer trying to push this task to either the importer or the broker.
Mm-hmm.
The broker generally is the party that has the best information to do this. They have all the early entries and all the documents and access to customs info. Now, having said that, I want to just remind everybody that number one, you must have an ACE account. If for no other reason, you need to go into that ACE account and give yourself an ACH refund if you're in the US. If you're not domiciled in the US and have a US bank account, if you don't have a US bank account, you have to give that task to someone who does, whether it's your broker, your lawyer, etc. Number two, you're going to need the data that's in ACE. It's taking a bit of time now. ACE is slow, the system is slow, and the processing is slow. But you should really be doing that immediately because that's going to be the ACE is the system of record, and that's the data that everybody needs to be looking at.
Agreed.
Todd,
Yes.
because time is getting short, can we segue to at least some of the guardrails content for people that were interested in that?
I'm actually thinking we should do a third-part series in our evolving webinar and go deep, into the guardrails for AI trade compliance, Leslie, as well as the AI enterprise AI adoption considerations. We only have
Right.
10 minutes. I don't think we would do it justice. But you're the boss, so it's up to you.
Yeah.
Like I think it would be great if we just go ahead and we'll have a part 3 to this series. I think it'd be terrific.
We can do that. I don't want to disappoint people who wanted to hear about the guardrails. Maybe you can give just a sneak peek
Yeah.
and kind of a preview to what we'll cover in that, so people can see kind of what the main points are.
Okay. All right.
There's
So
already someone saying yes to part 3.
Oh, yes. Okay.
well, we got 10 minutes, guys. Anyway, Richard, thank you very much. There's still a couple of questions in the webinar chat. And this has been a very, healthy discussion, and there's obviously a lot more to come on this too, but just not because I have you on the webinar, but I do agree, with the approach that you're laying out. I think belt and suspenders is, we've always kind of learned. I'm not a lawyer, but it's better just to make sure you cover your bases because you don't know, what decision is going to overturn the decision that we just heard, and you could be left, holding the bag with nothing because you didn't do these filings. At a minimum, I would think the protest.
Well, we are getting a lot of comments that people are happy with the content and it's informative. And so,
Great.
if we want to continue with this, we've got a few minutes. There may be, I don't know, Anand, a question or two that was not answered.
There are a couple of questions, but I'll leave it to you, Leslie. If you want the last 5-8 minutes to be on AI, we can do that. Let me quickly ask the questions as we are thinking through that. Richard, informal entries also are covered. I know you mentioned it, you talked about it, but can you just clarify on informal entries?
About a refund opportunity?
The IEPA refund opportunity, yep.
It looks like Richard may not have his audio on.
No, I'm sorry. I'm trying to
Multitask.
push back my next call by a couple minutes so I can make sure I give everybody their due time. Although this is what I think that we need to, what
You,
I would propose here.
you heard the question on the informal
Informal
entries
entries.
in the IEPA
Well,
refund process?
informal entry, I did not hear the question. So let's repeat the question. And
So the IEPA refund process that we are talking about, does it cover the informal entries or is there a special treatment?
well, that's a good question. And if you asked that question 9 o'clock this morning, the answer was no. If you ask the question afterwards, today, Customs published in court more to the system. So if you read together what Customs is supposed to be doing and what the court said they're supposed to be doing, that should be swept up in the process. I do want to remind the importers that the data related to informals is only in ACE. If you use Customs Bulletin of Liquidation, which is on a website, you will not get the
liquidation date.
You won't get liquidation information.
Uh,
So that's important. Number two, informal entries liquidate very quickly, immediately upon entry. And so the only way those are going to be received back is either if you get a court order or this K program actually includes all the informal entries.
Can you protest an informal entry that liquidates?
You know what? I don't know that I don't know that I've ever done that.
If anybody knows
But anyway,
out there,
listen,
that's a good one.
I want to let you at least get 5 minutes in on Guardrails,
All right.
and we can certainly set up another program perhaps next week on IEPA, because I know there are some people who really want to hear a little bit about. I see in the webinar chat a battle back and forth about which topic should be next.
There's a battle.
Let's do a little bit on Guardrails because there's some people who the IEPA isn't even relevant to. So
all right. This has been really a great session, and I'm going to just touch on a couple of high points, maybe as a trailer, for an actual full hour on Guardrails, Leslie and everyone out there. So this is I guess just to set the stage and level set. In what I'm going to be laying out here are really, first and foremost, like the core problem around using AI in an environment that we're all operating in, which is a heavily regulated industry, with, very well written or arguably well written, regardless of whether it's well written or not. They are what they are: statute, laws, regulations, and rulings. And the issue with using AI to help interpret the regulations in the law, and especially as those regulations and laws apply to your fact pattern, the particular product that you're importing, is that LLMs produce plausible, but always, imprecise answers. And the reason for that is because the LLM models, the generative models, are all, using search and natural language capabilities that are semantic based. And so the AI models and algorithms are looking for streams of text and words that exist that sound similar, but may not necessarily be, an exact verbatim, output of the regulations. And so it also is really good. AI is really good. Generative AI is really good at putting, pieces of information from different corpuses of data really, really well so that it sounds good, and semantically. And so it's kind of the things that are so cool about generative AI in most contexts, become problematic in an environment where you're really needing to be specific from a regulatory standpoint. And so I think I've laid out why this matters in the lead up to this slide, which is that, the laws really are, and the regulations are literal. They are written in the way they are, because the author of the statute or the regulation, meant it to be a certain way. Now, everything's up to and subject to interpretation. That's why we have Richard. That's why we have courts. But nevertheless, regulatory decisions are usually defensible and source grounded. And the LLM and semantic nature of LLMs is doing something really different to interpret, those rules and regulations. And so it's from a governance standpoint, it's extremely important, that you go in with eyes wide open, knowing this. And the LLMs, and there's been asked, questions about LLMs in the chat. Really, don't have the training, if you will, to be precise. I will say that they're getting better. And I will say that you can ask in your own prompt with an LLM, a publicly available LLM, to not interpret, but to cite specifically the statutes and the regulations, and then give an opinion, on that site. But you really have to kind of work hard to keep the LLM, within these guardrails through your own prompting and filters. And so within a trade compliance standpoint, where you may be using AI to help you with, answers and coming up with the right decisions, you need to think about what I'm saying. Moreover, you really need a way to document, what it is, that you ask the LLM to do, and obviously the output, in a way that you'll have a record in an audit trail of how you got there, if and when there's an audit. And so coming up with a governance system and an audit trail around this becomes very important, very, very important in this world of generative AI, RAG, and LLMs. So we have kind of we put together some practical guardrails for how at least we are doing this in our platform at KYG Trade. We've already thought through all of the pitfalls and areas of risk around trying to do your job systemically long term with the right workflows and guardrails and human in the loop and audit trails. And we do have this, great, presentation, and we also have put together an enterprise AI adoption checklist. And since we only have 2 or 3 minutes, there's just not enough time to go through this. But I will just show you, and this is part of our slideshow, which we will make available to download. This AI adoption checklist covers discussion topics for cross-functional teams, outbound data governance, and human in the loop review and audit trails, inbound data scope and enablement risk, structured outputs and decision decomposition. These are all things, control architecture and monitoring, and then the source of regulatory truth, and making sure that that is a sustainable, repeatable, because the regulations are being updated all the time, and you have to, when you're asking the AI for answers, you got to make sure that the AI is citing the most recent, relevant, rules that are in effect. So these are all traps, that you're going to get into if you haven't gone through an adoption checklist like we put together. So we're going to make this available for download. But then we can also maybe have a full-on hour to get into this in our next webinar.
Yeah.
So I guess with that, Leslie, I'll turn it back over to you. And Anand, if there are any last-minute questions, we can address those.
I don't see any other questions, Todd. So Leslie, over to you.
Okay, thank you all. Really fantastic engagement. As we wrap up, I want to thank Todd, Anand, and Richard for sharing their insights today, and thank all of you for taking the time to join us. Great questions. If we didn't get to your question, we'll get back to you, but I think we've got everyone covered. We'll share a recording of the webinar, plus any additional resources that we talked about during the discussion, including like when are we going to have another one, and separating out the topics of the guardrails and maybe the regulatory situation that we're dealing with. Thanks again for joining us, and we hope to see you at a future session. Have a great rest of your day.
Thank you all.
Bye.
You.